All right, good afternoon, everyone. In what is now a CyCon tradition, let's begin right on time. So thank you very much for joining us for this panel. My name is Professor Kubo Mačák, and it is really a pleasure to welcome you all here this afternoon. We will have a fascinating panel on the topic of international law perspectives on artificial intelligence in armed conflict, emerging issues. And so I think you will all agree with me that CyCon has always been at the forefront of discussions on cyberspace and new technologies. And so this is also, I think, the right place and the right moment to share some exciting news with all of you. And that is that CCD-COE has recently launched a major new book project which will explore the legal dimensions of artificial intelligence in armed conflict. And so I have the privilege of acting as the academic lead of the project. And on the CCD-COE side, I have some excellent team, and I would just like to give a shout out to Nick Wobma, who is sitting here in the front, who leads the project on CCD-COE's end. And then in the back, we have Maria Tolpa, who is one of the researchers at CCD-COE and who is also supporting the project on CCD-COE side. So the book will be published by Oxford University Press as part of the prestigious Liber Studies series. And we have assembled a group of 24 leading and emerging experts from around the world, including our 4 panelists. And so each of them will contribute a chapter on a different aspect of this broad theme. And so the book itself will examine how AI technologies are reshaping the battlefield through their applications in areas such as cyber operations, targeting, decision support, logistics, and so on. And at its core, the book will assess how international law, and in particular international humanitarian law, or IHL, apply to these developments. And so I think, as you will see, today's panel is a sort of a preview of this book. And as I said, we're lucky to have 4 of the future chapter authors with us to present and to discuss their areas of research. And so to get us started, let me just say a few words about the scope of the book. And in doing so, in this way, by talking about the scope of the book, I'm also going to introduce our wonderful panel. So as the very starting point, as probably everybody in this room knows, there is no universally accepted definition of artificial intelligence. So just for our purposes today, we're going to take AI to mean the use of computers to perform tasks that normally require human intelligence, such as planning, problem solving, pattern recognition, or interpreting data. And we will focus on the use of AI for military purposes, or more broadly, in times of armed conflict. Now, the book itself will be structured into 4 substantive parts. And I'm pleased to say that we have an author representing each of the substantive parts on our panel. So, first of all, the first part of the book will be called Foundations. And it's an appropriate name because it will lay the groundwork for the rest of the volume. And so our first panelist is Dr. Antonio Coco, who is Associate Professor at the University of Essex. And Antonio is also one of the co-founders of the renowned Oxford Process on International Law Protections in Cyberspace, and the author of a number of peer-reviewed articles, as well as a monograph published by OUP. Now, Antonio's talk will examine the current state of international law as it applies to the use of AI in armed conflict. And so, in doing so, Antonio's talk will provide us with the basis for the rest of our discussions. Now, next to him is Anna Greipl, who is our second panelist, and her talk will reflect the second part of the book, which is focused on applications. So that part of the book will focus on how international law applies to specific uses of AI in times of armed conflict. Anna is a researcher at the Geneva Academy of International Humanitarian Law and Human Rights, and she's also a PhD candidate at the Graduate Institute in Geneva. In her doctoral work, she's focusing on the evolving role of human decision makers alongside AI systems in military operations. And so in her talk, quite appropriately, and tying on her PhD research, Anna will discuss the complex dynamics of human-AI interaction in decision support systems and the relevant legal implications. Then the third part of the book is called simply Cyber, and it will explore the intersection of AI and cyber operations during armed conflict. Our third panelist is Lieutenant Colonel Dr. Eric Pau, who is assistant professor in cyber operations at the Faculty of Military Sciences of the Netherlands Defense Academy. Now, in his talk, Eric will unpack the challenges that are posed by the use of AI in offensive cyber operations during armed conflicts from the perspective of international law. And then finally, part 4 of the book will be on compliance. And so this part will examine how to ensure that the use of AI during armed conflict remains within the boundaries of international law. And our 4th panelist is Neta Gusak, who is a senior researcher with the Stockholm International Peace Research Institute, or SIPRI. And Neta has worked as an international lawyer for over 15 years and has particular expertise in legal frameworks related to the development, acquisition, and transfer of weapons. And so again, very appropriately, that's also what Neta will be focusing on in her talk. She will talk to us about the critical role of legal reviews in safeguarding compliance with IHL when it comes to military AI capabilities. So each of our 4 speakers will address you for about 15 minutes. They have each prepared a presentation summarizing their findings so far. And we will then move to a joint Q&A. So please note down your questions as we go along. And with that, my role as the moderator opening the discussion today is complete. So I'm going to hand over to our first speaker. Antonio, over to you.
Thank you. Thank you very much, Kubo, and thank you to all of you who came to listen today. As Kubo said, my task for this project was kind of a stock-taking exercise to understand what is the state of affairs currently in multilateral discussions about the application of international law to artificial intelligence technologies in armed conflict. And when doing this, we must start from a foundational principle that international law is technologically neutral. This means that international legal persons, particularly states, are bound by existing rules of international law regardless of the tools that they use in their activity. This means that all the classic sources of international law continue to apply to the development and use of artificial intelligence technologies, starting from customary international law, but including also treaties like the UN Charter, the Geneva Conventions and their additional protocols, and also other treaties that often are kind of neglected in discussions in this area, like the regional and international human rights treaties. But of course, the main focus of discussions about international law and artificial intelligence in armed conflict has been on international humanitarian law, IHL, as I will be saying for this talk. And there is broad agreement that IHL applies to the development and use of artificial intelligence technologies with respect to armed conflict. Of course, the fact that it applies doesn't solve all the problems with its application. Indeed, the fact that there are new technologies may mean that new interpretations or an adaptation of the interpretation of certain rules may be necessary to make it more meaningful. It may be that the technological progress makes new conduct possible that is kind of outside of what was thought possible at the time that the rules were drafted. And in this case, it may be that there may be some gaps or some uncertainties to be solved by thinkers, by states, possibly by the formulation of new rules. Where are these rules being discussed? There is one forum that has been at the center of the multilateral discussions with respect to one particular artificial intelligence technology, being lethal autonomous weapon systems. This forum is the group of governmental experts on lethal autonomous weapon systems that was established in 2016 as part of a specific treaty process. That's the framework of the United Nations Convention on Certain Conventional Weapons. For those who are not familiar with it, this is a convention with 127 high contracting parties or states parties, 4 signatories, that acts as a framework for specific protocols on certain specific weapons. And in this case, a group of governmental experts was set up to consider the technical ethical and legal aspects of lethal autonomous weapon systems, with a specific mandate that includes potentially leading to a new binding legal instrument, a treaty, most probably, to be agreed upon or at least drafted in its very early form by 2026. Of course, also in this group, when looking at the specific rules that have been analyzed, the focus has been on international humanitarian law. What has this group of governmental experts achieved? The group has been subject to lots of criticism for the slowness of its proceedings, for the seeming stall in many of the discussions, but still, it does have something to show for. There are some instruments, some documents that the group of governmental experts has released that are very helpful in moving the discussions forward. And the first starting point is that in the discussions that have been held so far, and as they stand right now, there is no doubt, there is consensus, in fact, that IHL applies fully to the development and use of lethal autonomous weapon systems. In addition, between 2018 and 2019, the group of governmental experts adopted some guiding principles, initially 10, then they became 11. These guiding principles are meant to be the pillars, the foundations for all the discussions that followed in the years after. They touch upon topics like the application of IHL, including the fundamental principles of IHL, like distinction, proportionality, precaution, unnecessary suffering, the protections for civilians and the civilian population and civilian objects, and also principles like the human involvement, which is seen as instrumental in guaranteeing that autonomous weapon systems can be used in compliance with IHL. The guiding principles also touch upon accountability and measures to be adopted in the development of autonomous weapon systems in order to ensure that their development and use are compliant with IHL. The GGE has followed two approaches, one substantive and one procedural, with respect to the preparations for this binding legal instrument. Substantially, the group has adopted a two-tier approach. The instrument that's being conceived right now is divided broadly in two parts. One part containing prohibitions for weapons that cannot be used in compliance with IHL, and one part contains regulations for those weapons that can be used and therefore developed and used. In addition, procedurally, since 2023, the group has decided to adopt the technique of a rolling text, principles upon which there is consensus between the members of the group of governmental experts have been translated into a document that has been published periodically. And if we see at all these rolling texts that have been released over time, we see an increasing specificity and specification of the rules or potential rules on which there is consensus. The latest iteration of the rolling text is dated just a couple of weeks ago, 12 May 2025, and it was also the subject of discussions at some informal consultations that took place just immediately after. The rolling text right now touches upon several themes. I put some of them in the slide: a working definition of autonomous weapon systems, the application of IHL, prohibitions and regulations, further measures to be taken, especially in the development of IHL, of autonomous weapon systems, and also rules or potential rules on responsibility and accountability. DGG was not the only body to deal with autonomous weapon systems, because the United Nations General Assembly has also been quite influential in multilateral discussions about the application of international law in this field. And the General Assembly has issued particularly 3 resolutions that I think are quite worth noting. The first one is Resolution 78/2041 from the year 2023. This is widely regarded as the first meaningful resolution of the General Assembly dealing with lethal autonomous weapon systems. And I think it's very important because it signals the starting point, which is that international law applies in its entirety to these technologies, and particularly the General Assembly singled out the United Nations Charter, IHL, and international human rights law. In addition, I find this resolution particularly important because it signals that this process of thinking about these rules is not reserved to states, but it needs to include other stakeholders, including industry representatives, civil society, and academia, represented by so many people today. In 2024, the General Assembly went back to the topic twice. In the first resolution that I put here in the slide, they expanded the set of subfields of international law that they deem is relevant for artificial intelligence, and that includes international criminal law, signaling the importance of thinking about accountability, meaningful accountability for humans that interact with these technologies. And in addition, these General Assembly resolutions called for the informal consultations that I referred to before that took place in mid-May, and I'm sure will feed into the next initiatives of the GGE and of the other bodies that I'm mentioning today. Still in 2024, the General Assembly also adopted a resolution that deals with technologies beyond lethal autonomous weapon systems. So this is a resolution that broadens the scope to all forms of artificial intelligence in the military domain, and stresses that rules of international law are important not only for the deployment of artificial intelligence technologies, but at all the stages of the life cycle of artificial intelligence. And then in order to make meaningful progress on governance, it's important that states cooperate between themselves and that they exchange their knowledge. The Secretary General of the United Nations has also been involved in many of these discussions with a role of beacon in a way. The Secretary General has been quite vocal in endorsing the possibility of a binding legal instrument and endorsing particularly the two-tier approach, saying very clearly that he believes weapons that cannot be used in compliance with IHL must be banned, and that all the other ones must be regulated. The Secretary General of the United Nations has also been particularly helpful in collecting the views of states and other stakeholders and analyzing them, posing the basis for further discussions and highlighting areas of possible consensus between all the various stakeholders. The initiatives by the United Nations are not the only ones, of course. You may have heard about other initiatives in multilateral fora, and I wanted to highlight three today here. Three that I believe have been quite important in shaping the discussions. The first one is an initiative that I would say it's a multi-stakeholder initiative, even though it was initiated by the government of the Netherlands with support of other states, including Korea. This is the Global Commission on Responsible AI in the Military Domains, also known as GC REAIM. It was established in 2023. It's an independent group of experts that come from different backgrounds, and it's tasked with providing a comprehensive report by 2025 on the responsible use of military AI, a report that touches upon legal, ethical, and technical considerations. And they have published a series of documents in the lead-up to this final report. One document that I think is quite important is the blueprint for action that was agreed upon by the members of the Global Commission in 2024, that also includes language to the effect that international law applies fully to the development and use of these technologies. I also think that when talking about international law and artificial intelligence in armed conflict, we cannot avoid mentioning the International Committee of the Red Cross. The ICRC in 2021 published a position paper in which very firmly expressed their support for banning autonomous weapon systems that cannot be used in compliance with IHL. And I think this has been quite important because it signaled a red line and created the opportunity for other stakeholders to support the position. There have been not only multilateral initiatives, but also individual states-led initiatives. One with whom many here will be familiar, it is the Political Declaration of the United States on Responsible Military Use of AI and Autonomy. This was released in 2023. It has been endorsed by over 50 governments around the world, and it also implies that international law, particularly actually, international humanitarian law continues to apply to the use, at the very least, of these technologies. So where does that leave us now? Well, with respect to the work of the group of governmental experts, I think more work will come and should be done on clarifying the necessary levels of human judgment and control over autonomous weapon systems, on the measures needed to comply with IHL, and on ways to ensure human and state accountability. But I believe that more work needs to be done with respect to artificial intelligence technologies other than lethal autonomous weapon systems. And I believe that other fields of international law, other than IHL, should receive equal attention and equal consideration, particularly human rights law, state responsibility, and rules with respect to individual criminal responsibility at the domestic or at the international level. What will be the outcome? I cannot say, maybe some of my colleagues. Whether it will be a binding instrument or non-binding instrument, or perhaps a combination of the two, it is to be seen. But perhaps we can discuss this during the Q&A. For now, I would like to thank you, and I'll give the stage to my colleague. Thank you.
So thank you, Antonio. I'll just say a word. It's fantastic for you to give us this overview, also highlighting how the debate has shifted from autonomous weapon systems to broader military applications when it comes to AI technologies. And so for that, that's an excellent moment to pass to Anna, who is going to focus on the use of AI in decision support systems. So Anna, you have the floor.
So yeah, thank you very much, Kubo, for your kind introduction. It's a great pleasure to be here today with you to discuss the growing role of AI DSS, decision support systems, in military decision-making. While much of the legal discussion thus far has focused on the risks of AI DSS in military decision-making, and yes, they are real, I propose we shift today our approach towards the opportunity this new reality offers us to recenter the role of human in IHL decisions. However, first, let me establish a shared understanding of what we mean by AI DSS. At the outset, it is important to recall that the use of DSS, and here I mean non-AI-based DSS, in military operations are nothing new. But the integration of AI into DSS has introduced a host of new complications, many of which are less visible and less traceable than those associated with earlier, more traditional forms of DSS. And at the heart of this development is machine learning. In contrast to earlier forms of AI techniques that have their knowledge provided by humans in form of hand-programmed rules, machine learning-based AI DSS can highlight certain data points and prioritize or select features based on predetermined features and self-learned patterns without human intervention. Now, it is essential also to start our discussion with a distinction between AI DSS and what we also already heard about, autonomous weapon systems. An autonomous weapon system, by definition, selects and applies force to a target without human intervention. But today, I'll turn our attention to AI DSS, which on the surface seem far less controversial. In contrast to the former, these systems are designed to assist or support, but not replace human judgment in military decisions. And yet, The difficulty or risk with these systems is that in practice, even if they don't make decisions, they do end up directly and often significantly influence human decision-making. This is particularly concerning as we see AI DSS increasingly integrated further down the chain of command to support and assist the human decision makers in legally relevant decision-making processes, including those associated to the use of force. Taken together, this brings us to the question that lies at the heart of ongoing legal and policy discussions. What role do humans play in legally relevant IHL military decision-making? The view on that question continues to differ. The divergence is often attributed to the absence of explicit guidance in IHL. Now, still, there are some provisions that reflect that some human judgment is involved in legal decision-making processes. For instance, Article 57 on precautions in attack suggests in its wording those who plan or decide upon attack as a reference to humans, and similarly Article 36 of Additional Protocol 1 in its notion, its employment makes some sort of reference to humans. Now this provision also may help us to shed light on IHL's conception of the human and its relationship to the technological form of existence. There are two important notions that I wish to highlight here in terms of that conception. First, IHL portrays the means as mere tools in the service of human. So they are presented as neutral and strictly separated from humans. Second, IHL tends to conceptualize the human not only as strictly separate from the technology, but also as hierarchically superior to what the military language calls material, often associated to a notion of control exercised through the capacity of rational reasoning. Placed back now in the context of AI DSS, the risk of this binary vision and the emphasis on rationality is that it supports ideas promoted by powerful AI scientists and business leaders that AI systems are to be soon, if not already, smarter, wiser than we are. These actors promote the idea that algorithmic decision-making processes emanating from prescribed forms of logical interference will necessarily increase legal certainty and facilitate the objective application of the law by transcending human biases and error. Although acknowledging that today AI systems face limitations, these actors also widely promote the belief that technological objectivity can be preserved as these challenges can be mitigated through technological progress alone. Following the view as reflected on my slide, the more refined an AI system becomes, the more tasks it can be assigned, and the less human user judgment will be needed during the execution of decision-making tasks, including perhaps those associated to the use of force. These premises explain why states are driven by the vision that AI DSS will enable military decisions to be made more efficiently, more accurately, and with less biases as if they would be made by human actors, and thus contributing what militaries consider a decisive military advantage, famously encapsulated in Joy Boyd's idea of the OODA loop. But shouldn't we ask ourselves whether this vision of technological capacity is accurate? Because if AI systems are positioned to deliver the objectivity that AI IHL decisions seem to aspire to, what then remains the role of humans in legally relevant decision-making process? These questions, I think, are critical because this vision has significant implications. But to understand these implications, I also believe it is necessary to engage with the co-constitutive ways human and AI DSS in decision-making processes relate. The growing discussion on the military use of AI DSS have highlighted the fact that these systems bring novel legal and humanitarian challenges. Now, without entering into the detail of these challenges, what I would like to emphasize instead here is one of the key findings, also including part of the research that is highlighted here, a joint publication with the ICRC and the Geneva Academy. And here the fact is that many of these challenges do not pertain to the technology itself, but are ingrained in the relationship between humans and AI systems, meaning also that they are very likely to persist. This is why I believe that the understanding of that relationship is necessarily a step to recenter the role of the human operating alongside the technology in legally relevant decisions. An understanding of this relationship begins with recognizing that AI DSS do not emerge in a vacuum. They are shaped by humans in multiple ways, whether through the choice of developing one technology rather than another, or through human developers' countless design choices and assumptions that translate data into actionable information. In other words, human assumptions, choices, and values are inherently shaping AI decision support systems. Now, at the same time, AI DSS in turn shape human behavior too. These systems predetermine the value of human users' decisions and actions, often in ways that extend our conscious choices. This is often still a rather neglected aspect of the relational nature between human and AI systems, but actually something most of us experience in our daily activities, including when we opt for Netflix top pick for you instead of searching for an alternative option. Now, of course, this influence becomes particularly apparent in situations where this over-reliance has dire repercussion. But what these instances provide us is a critical entry point to rethink the human-technology relationship in IHL, one that no longer relies on a strict binary distinction between human control and is not reduced to a single point. Now, one may rightfully wonder, how does this approach present us an opportunity to recenter the role of humans in the discussions on the military use of AI DSS? I won't be able to provide you an exhaustive list of those potential of this co-constitutive approach, but I will try to highlight some of these here. A first core aspect I wish to highlight here of this approach to human-AI relationship is its capacity to demystify misleading promises surrounding AI DSS. It challenges the frequently oversimplified view that AI systems as an objective tool can and asks for a more nuanced understanding of AI systems' DSS roles in military decisions, including when it's associated, especially when it's associated to legally relevant decision-making. Importantly, it does away with the strict binary distinction between humans and technology, thus rendering the often posed questions of whether technology or humans are better at complying with IHL obsolete. Instead, it invites us to ask how humans operating alongside AI DSS can best uphold the rules and principles of IHL. In this way, the approach renounces to our tendency also to anthropomorphize AI DSS and then assume that these have to pass a human standard set by IHL to be lawful. It also dispels the idea that the technology is merely a tool to fix human weaknesses. Instead, it invites us towards a more creative thinking about how DSS can upskill human decision makers rather than leading to a descaling effect where military decision makers become less adept at evaluating combat situations critically or recognizing the intricacy of IHL in practice. This brings me to the final opportunity I wish to highlight here today, namely the capacity of this approach also to expose how reliance on AI DSS risks subtly reshaping IHL itself. The realization means that we cannot downplay concerns about AI systems' output, assuming that as long as these outputs do not directly classify an individual status under IHL, their impact is minimal. Let me elaborate on this a bit because I think it warrants further attention. Military decision-making often occurs under high-pressure conditions where decision-makers have limited time and space to thoroughly engage with information provided by AI DSS. This may result in misclassification or the unlawful use of force with serious consequences, thus placing time and restriction and ensuring sufficient space for human decision makers to critically engage with AI DSS outputs are certainly key measures for such an approach, that such an approach would invite us to take, but unfortunately they also risk being insufficient, at least as long as tech companies driven by profit motives play a central role in the development of these technologies. The risk is that these systems are applied in the name of accuracy and objectivity to decision-making tasks in IHL space of interpretation and argumentation without following IHL's roadmap of justification. To put it differently, the risk is that the space of legal reasoning becomes one of algorithmic logic driven by optimization and speed that is hard for any human to notice. And I'm afraid that ultimately what we think IHL and its foundations are might suddenly be too far from what IHL has become, all while we remain blind to this discrepancy. To conclude, in the limited time available, this reframing demands us to move beyond a narrow instrumentalism. It compels us to consider instead how these AI DSS should relate to us and how we, in turn, should engage with them to cultivate the kind of legal culture we aspire to live in. This shift in perspective is especially critical in the context where technologies are not just instruments for accomplishing a task, but they also reshape the very nature of what it means to be a military decision maker. And perhaps most importantly, I think, the approach should invite us to have more faith that we humans do have everything in us to make IHL compliance a lived reality. Part of this creative effort is how AI DSS can enhance human decision makers' capabilities to comply with IHL rather than further erode them. And this effort, I invite you all to take part in. Thank you.
So thank you very much, Anna, for providing us with what, at least for me, is a powerful reminder that when we think about how effective IHL is in regulating this field, it's not enough to think about the role of the human, and it's not enough to think about what the AI tools can do, but we need to also focus on the relationship between the human and the AI technology. So thank you very much for that. Next up, we have Eric, and we shift from decision support systems to the use of artificial intelligence in offensive cyber operations. Eric, over to you.
Thanks so much, Kubo. And thank you for having me. I would like to highlight at the start that the writing of this chapter is not done by myself, but in cooperation with my dear colleague, Colonel Peter Pipers. But since he outranks me, I have the privilege of standing here to present what you can consider our preliminary findings of first steps into the party world of AI, because both of us, we barely knew how to write artificial intelligence 2 months ago. And what we tried to do is to set our first steps into this new world of AI, and then in relation to offensive cyber operations, during armed conflict. So it's a combination of at least 3 elements. AI use in offensive, 4 maybe, offensive cyber operations in armed conflict. And well, what we did is we dug a hideout, took out our binoculars and started to observe this phenomenon. And what I would like to present to you today are these 2 issues. So first of all, if you look at AI use in offensive cyber operations, what are you talking about in the first place? That was a question that came up immediately. And the second one is, if you look at challenges that this AI use in offensive cyber operations may pose, what makes them unique? Because we all know that there are challenges out there, but what sets them apart from AI use in offensive cyber operations? So let's start with the first. And the definition of what offensive cyber operations to most of you should not come as a surprise. But of course, the main term here is the word offensive. Offensive meaning that from a military perspective at least, you attack something. Could be a person, could be an object, could be a physical object, could be a non-physical object like data, with the purpose of gaining some kind of advantage over an opponent. And you take the initiative, and that's what it sets it apart from, for example, defensive cyber operations, which are more preventive and in reaction to. But the key word, like I said, is offensive. And in normal parlance, you could say, okay, whatever cyber operation is offensive, you could call it an attack. We can call it a cyber attack. And then the conclusion could be, okay, what walks like a duck, quacks like a duck, and whatever, it must be a duck, but it isn't. And that's one of the crucial issues here when talking about AI use in offensive cyber operations, and it's an issue that I will come back to in a few minutes. Another thing is, what kind of usages, applications of AI are there in relation to offensive cyber operations? And I'm working at the Netherlands Defense Academy as an academic. I'm not into or in any way involved in cyber operations, and so I have no knowledge of what's going on there in that world. And if I did, I couldn't share it with you. So just like you, I'm probably as much dependent on open source information as you are. And the picture that emerges to me is that it is very murky. All kinds of different terms, names, whatever descriptions of AI, which are very technical, and I'm not going to repeat it here. But an overall picture can be given, which is the picture there, that AI use can be either very rudimentary, for example, and then I'm referring to the last bullet, AI that you can use, for example, to train operators or to train a system that you built, to test it in a red team, blue team kind of setting. Or perhaps if you're working in a team, you can use AI to create a better work performance. That's also AI use in relation to cyber operations. Another one is if you look at the targeting cycle for cyber operations, of course, then there's all kinds of decisions that need to be made normally by humans. But the question could also be, why not let AI do that for us? Or at least let it play a role so that it can advise us, or maybe give us recommendations, for example, on targets or collateral damage. And that is, a variant of AI decision support systems, but then applied in offensive cyber operations. And then the last one is obviously cyber weapons, malware, whatever that you need in your attack, but are now AI enabled. Now, I'm going to come back to some of the risks involved with this. But this was the picture that came to us. So there's all kinds of applications of AI in relation to offensive cyber operations. Now this question, so what makes it all unique? Well, we found it difficult to answer that question. And the first observation that we made was, if you look for challenges, then there are a lot of challenges to begin with that already exist. And AI is something on top of it. So let me work out 3 examples. The applicable legal framework, challenges arising from discussions about the application of IHL to cyberspace, to cyber operations, and challenges arising from characteristics already present in cyberspace. So to begin with the first, and now we come back to this notion of attack. What we did so far, and Kubo can confirm this, is that we looked specifically at offensive cyber operations that have reached or crossed the threshold of attack as understood in Article 49 AP1. And as you probably are aware of, there's a lot of discussion about this threshold. You know, the ordinary meaning being, okay, you have to kill something or injure somebody or destroy something. But the other interpretation being, okay, if there's a loss of functionality, maybe then you also cross the threshold. The problem being with offensive cyber operations is that probably the vast majority of offensive cyber operations taking place at this very moment do not take place in the context of being an attack under Article 49 AP1. That's only a very small portion of it. And that's relevant because it means that if it's not an attack under Article 49 AP1, then it's not governed by the law of hostilities, and it must be governed by another framework. For example, if offensive cyber operations take place in peacetime, which is very possible, IHL doesn't play a role at all. Then it's human rights law. If it's not the law of hostilities because it's not an attack, then other rules, more general rules of IHL apply, but not the ones dealing with, for example, proportionality. And each of these separate legal regimes, and I haven't even touched upon a further diversification of this little object that we're discussing here, in relation to what if not a state, but non-state actors do this? Of what if it's in relation to a non-international armed conflict instead of an international armed conflict? All these different legal regimes have their own inherent legal issues. Think, for example, of the notion of extraterritorial applicability of human rights law, which is an issue in itself, already existed long before AI, still isn't answered, or it is answered partially, but still under debate. But the question, of course, then is, for that big group of offensive cyber operations, how does AI then relate to that particular notion? That's something, I believe, Kubo, we're not going to cover in the book, right? But it is you know, it's probably a relevant issue that needs to be addressed somehow. Because, you know, this is in the context of an armed conflict, which is, of course, a legal term. But looking at it, the point from cyber operations, offensive cyber operations are part of warfare. And we're already waging war, not in the sense of an armed conflict, but we are already waging war in peacetime. Yeah, it is happening under our eyes. So, second one is challenges already existing from the application of IHL to cyberspace, to cyber operations. I'm just going to mention the 3 on the slide, just to mention them, but they have been around and are still under debate. What is an attack? Is data an object? Or a more broad phenomenon, how is DPH applied in cyberspace to cyber operations? Already there before AI came around. And then the last which is challenges existing because of how cyberspace is how it is. You can do things anonymously, which makes it hard to point out who was the targeter. The fact that a lot of the infrastructure we use is dual use. When does an operation start an armed conflict? When does it start to begin with? Does it start an armed conflict? Etc. Now, a second observation with respect to offensive cyber operations and the use of AI is that of the challenges that you can relate to AI, they're not really unique to offensive cyber operations per se, because they already exist in what I would like to refer to as, like, say, normal or traditional operations. And in this context, I would like to refer to much of the research that has been done so far to, for example, the operations by Israel in Gaza and the alleged use of AI in that context. And if I may refer to an article that's upcoming from Marta Boo and Jessica Dorsey, which is going to be published in International Law Studies. On this issue, I really recommend it because it's looking at this very issue from an AI DSS standpoint in relation to the joint targeting cycle. Interesting article, I recommend it to read. But what does this research show? Well, it shows that at one side, there are some advantages attached to the use of AI. Autonomy, it speeds up things. It's very, you can use it in for all kinds of purposes, etc. And at the same time, there are some disadvantages, some pervasive issues that linger around the use of AI at all times. The quality of data, how good is it? How reliable is it? The opacity of AI, the black box of AI. What does it decide? How do we know? How can we find out? And then the human-machine interaction, or system vulnerabilities. How reliable is the system? What if somebody else breaks in and poisons your AI? Then you have a problem. Now, these two issues, the advantages and disadvantages, they press on IHL. And in particular, if you look at it from the context of the law of hostilities on basic principles as distinction and proportionality and precaution. How does AI work? How does it make decisions that are normally to be made by humans? How does it measure the expected civilian harm or excessiveness in relation to the concrete and direct military advantage? How does it work does it doubt? Does it doubt in making distinction between civilians and combatants? Or a military object and a civilian, military objective and a civilian object? What does it mean? How can it think like a human? Or should we leave it to AI to do that? So does it mean that there are no unique challenges at all? I don't think so. There are a lot of challenges in relation to AI use for offensive cyber operations. But these challenges are existing challenges that are intensified by AI. And they raise really, really important questions. So the takeaway, and I have 30 seconds left, cool. For me is this, don't blame AI for everything. Look beyond it. Look at the real source for the challenge, and then decide how you're going to deal with it, legally or in your policy decisions. But there are serious challenges, and for me, one of the prime concerns is the human in the loop. And if I might close off with a podcast that I listened to a couple of weeks ago, in which a professor working at MIT was interviewed, talking about the likelihood of artificial general intelligence being launched upon us in a matter of years. Then we have a completely different discussion, because then we leave everything in the hands of AI. And the question is, do we really want that in our daily lives, let alone when waging war? So thank you for your attention, and I'm looking forward to your questions.
So thank you, Eric, for systematizing the challenges that, on the one hand, AI poses for military operations that we have talked about before, then the challenges that cyber operations pose for IHL that we also have had some discussions about. And I think the biggest question for us and for your chapter will be the intersection of these two Venn diagrams, right? When it all comes together. And so that's a really thought-provoking presentation. Thank you for that. And so Anna has already mentioned Article 36, legal reviews, and that's what we move on to now with Neta's presentation, that will look at legal reviews of military AI capabilities. Neta, you have the floor.
Thank you. Thanks, Kubo. As Kubo said, my name is Neta Gusak. This is the first time that I'm participating at CyCon, and I'm very pleased to be here with you all. And I'm very grateful to Kubo, to Maria, and to the other colleagues at the CCD-COE for supporting my presentation. As Kubo introduced me, I'm a researcher with the Stockholm International Peace Research Institute, as well as it said on the introductory slide, special counsel with Lexbridge, which is a public international law consulting and advisory firm. But my remarks today are really based on work that I've done in my individual capacity, and so don't necessarily reflect the views of those two organizations. Specifically, my remarks reflect research undertaken together with a working group comprising Dr. Damian Copeland, Dr. Natalia Yevlevskaya, Dr. Rein Levoya of Estonia, and Dr. Lauren Sanders and Dr. Renato Wolf. I'm the only non-doctor in this esteemed group. Together, we are working on publishing and developing good practices in the legal review of weapons, means, and methods of warfare. These good practices are being drafted through an iterative process which draws on submissions made to the group of governmental experts on lethal autonomous weapon systems, which Dr. Coco mentioned, as well as through consultations with government, industry, civil society, and academic experts. These good practices are intended to assist states to assess the legality of weapons, means, and methods of warfare in advance of their employment in armed conflict, what's known as a legal review. Part 1 of the good practices is relevant to all legal reviews, whereas Part 2 accounts for the unique considerations in the legal reviews of autonomous weapon systems, including autonomous weapon systems that rely on artificial intelligence. And over time, we intend to expand Part 2 in order to add parts that are related to other types of specific technologies, including military AI capabilities more broadly and cyber capabilities. It is this work with this group that has influenced this presentation, as well as the relevant chapter in Kubo's forthcoming book. To explain more, I will first talk about why legal reviews are relevant to the development and acquisition of military AI capabilities. I'll then talk about what challenges states may face when reviewing the legality of these capabilities in advance of their employment. Thirdly, I'll outline the elements, as we see them, of effective legal reviews of military AI capabilities. And finally, I'll share some additional further considerations that may bolster the effectiveness of legal reviews. Turning to why military AI capabilities are relevant to legal reviews, the short answer is that many military AI capabilities, or all of them in fact, should be the subject of a legal review because the military AI capabilities apply or affect the ability of states and individuals to implement and comply with their obligations under international law, including international humanitarian law. As the other colleagues on this panel have explained, militaries use artificial intelligence for a range of functions, not all of them related to warfighting, but the types of military AI that have drawn the most attention and which are the subject of this presentation and the presentation of my colleagues, involve the use of AI to support autonomous identification, selection, and application of force to targets, so autonomous weapon systems, the use of AI to support military decision-making in military operations and attacks, like decision support systems, and the use of AI in cyber operations. The use of these kinds of AI capabilities may be subject to a range of international and national legal obligations. The principal set of obligations, of course, derives from international humanitarian law, as Dr. Coco explained. And under IHL, the right of parties to an armed conflict to choose the means and methods of warfare is not unlimited. There are rules. States have placed constraints on this choice by agreeing to prohibit or limit the use of particular categories of weapons and by developing general rules that prohibit the use of weapons, means and methods of warfare that have certain effects. And there are also key principles of IHL governing the conduct of hostilities that affect the choice of means and methods of warfare, including the principles of distinction, proportionality, and precautions, and the prohibition on the causing of superfluous injury or unnecessary suffering. As Anna explained, a connecting thread in these rules is that IHL requires individuals to make legal determinations, for example, determining whether a target is a military objective or determining whether an attack is proportionate or will be proportionate. And the International Committee of the Red Cross has explained that it considers that human judgment is crucial for ensuring compliance with international humanitarian law. So fighters, parties to armed conflict, can use AI-based tools to support them in making these kinds of legal determinations, but the tools don't replace the need for the human to make certain decisions and for those decisions to be bound by international law. A key mechanism for ensuring that parties to conflict can respect and ensure respect by their own armed forces for these rules of international law is the review of new weapons and means and methods of warfare prior to their employment to determine whether they can be used in compliance with these obligations. And that's what we term a legal review. These legal reviews can be part of a state's general efforts to ensure the effective implementation of its IHL obligations. But for states that are party to the first additional protocol to the Geneva Conventions, they have a specific obligation under Article 36 to undertake legal reviews. Legal reviews can be a really potent safeguard against the development and use of artificial intelligence capabilities that are incapable of being used in compliance with international law regulating warfare. And this is reflected by the frequent reference to legal reviews in statements adopted by states recently in relation to military AI, both of which have been mentioned in previous presentations, such as the Re-aim Blueprint for Action and the US Political Declaration. Approximately 20 states have shared public details about their national legal review procedures and practices, and this includes states that are not party to the first additional protocol, as well as states that are. So in this presentation, I'm not going to continue to repeat the distinction between states that are subject to a legal obligation to conduct a legal review and those that are not. I'll speak more generally, but of course, I'm happy to answer questions about that at the end. So normally in a legal presentation like this, especially on legal reviews of new technologies, we would throw up the text of Article 36 on the screen and work through how military AI capabilities fall within the scope of the language of Article 36 and how this language can be interpreted in order to assist states to understand what their legal obligation is. But today, here, I wanted to take a more pragmatic approach, given that states can and should conduct legal reviews of military AI capabilities for a whole range of reasons, including policy reasons, not limited to their obligation under Article 36. And also because Article 36 itself doesn't prescribe how legal reviews are to be conducted. It gives us limited guidance as to how these processes should take place. And that is the real challenge that states are facing, not whether to conduct legal reviews, but how to do them effectively. So that's what I wanted to focus on. And I'll focus on a selection of the challenges that through the research that my colleagues and I have conducted, we've heard that states face. So the first of these challenges is the question of scope. What should be reviewed? Some states limit legal reviews just to weapons as they conceive them, either as a matter of policy or as a matter of practicality. And it's undisputed that weapons of all types should be subjected to legal reviews. But AI components incorporated into the critical functions of a weapon system are not the only types of AI that should be subjected to a legal review. Some military applications of AI, such as decision support systems, are not classically understood as weapons, but may need to be reviewed, particularly if they form part of a weapon system, that is, the means of warfare, or the way in which the weapon system is being used, in order to properly assess whether the employment of the weapon would be prohibited in some or all circumstances. Yet other military applications of AI may not fit neatly at all into this kind of weapons-based conception of what should be reviewed. For example, AI DSS that are not integrated into a weapons platform but are used for other kinds of functions related to combat, or even those systems that are used for general operational planning, training, information management. There is a real question for states on whether and how to review the legality of these kinds of systems. My view is they should absolutely be reviewed, but this is certainly a challenging question for many states. The next challenge I wanted to mention relates to the criteria for review. Of course, the central criterion is whether the AI, through its design or method of use, will prevent the user from exercising the judgments required by international humanitarian law. But how do you translate this central criterion into questions that a legal reviewer can practically ask as part of the legal review process? What are the questions that should be asked, and what are the standards to apply? The next challenge to mention, and this is a persistent challenge for reviewing the legality of means and methods of warfare, is the challenge of accessing empirical evidence during the legal review process, particularly at the early stages of development and acquisition. A reviewer needs to examine, for example, documentation from the manufacturer on the characteristics and performance of an AI capability, as well as the results of tests and evaluations. But ensuring that these are available to the reviewer can be really challenging for a number of reasons. And a legal reviewer faced with a lack of empirical evidence may find it necessary to caveat their conclusions, which potentially limits the utility of that legal review. Relatedly, the ability to carry out a legal review of weapon systems that utilize artificial intelligence entails a full understanding of the weapon's capabilities and foreseeing its effects, notably through verification and testing. But technical performance of an AI capability, particularly one that relies on machine learning, can be really difficult to evaluate, not least because of the lack of transparency in how AI, and particularly machine learning systems, function. A final challenge to mention here is that of modifications. Because computer systems, software is more readily modified than physical systems, the legal review requirement may arise more frequently in relation to military AI capabilities than in the case with military hardware. This is because modifications may impact on the ability of the user to comply with their obligations under international law and therefore affect the validity of the legal review that was conducted prior to the modification. At the same time, not all modifications of military AI systems may warrant a new or revised legal review, such as minor or incremental upgrades. So the question is where to draw the line. For legal reviews of military AI capabilities to be effective, states have to address and overcome these challenges, as well as a whole host of other challenges that I haven't had time to mention. But thankfully, there are steps, many of which states are already taking, in order to address these challenges based on at least the research and conversations that my colleagues and I have had. These include, for example, articulating criteria for determining which capabilities should be the subject of legal review, ideally keeping in mind not only what the definition of a weapons, means or method of warfare is, but also what kinds of capabilities impact on the ability to comply with international humanitarian law. It also means unpacking criteria, requirements for what IHL requires when users use military AI capabilities. And at minimum, as Anna has pointed out, this means setting criteria for assessing or assessing the human-machine interaction, the interaction between the user and the capability, in order to determine whether the human, the user, will be able to fulfill their obligations under international law. Of course, the challenge being that it's not clear exactly what level and type of human-machine interaction is demanded by international law. Keeping in mind the time, let me just mention a few other short steps. States could articulate the requirements for reliable and independent testing, evaluation, verification, and validation to inform legal review processes. They could identify and require the use of specific procedures, for example, methods, environments, and protocols, specific standards and models of performance, including in relation to reliability and predictability, given the centrality of these concepts for compliance with international law. And they could also specify the circumstances under which a modification to a military AI system may require a new legal review or a reconsideration of an existing legal review. Modifications to a military AI system that may require reconsideration of a legal review could include, for example, changes to the way the user interacts with the system or the system algorithm and data sets, both training and operational, as well as the intended operational environment of use. To conclude, many military AI capabilities will need to be and should be the subject of legal reviews. That is, states will need to assess in advance of employing military AI capabilities whether the users will be capable of complying with their obligations under international law. This isn't without its challenges, many of which are persistent challenges with conducting legal reviews in general. But as I mentioned, there are measures that states can take in order to address and overcome these challenges. I wanted to make some additional reflections, but in view of the time, I'll save that for the Q&A session. So thank you very much for the time.
And thank you very much, Neta, for your presentation. From my perspective, legal reviews are a fundamental aspect, almost a cornerstone of IHL and effective compliance with IHL. And thank you very much for showing how they would apply in the context of military AI applications and what the elements of effective legal reviews would be. So I very much look forward to reading all 4 of your chapters in due course. But of course, for the purposes of today, it's still very much work in progress, and we welcome feedback from all of you. And typically at CyCon, at this stage, there are quite a lot of questions in the room. We have about 20 minutes left in the session, 17 minutes left in the session. So I have prepared a couple of questions for all of our panelists, but we talk all the time about the book. So it would probably not be the right of me to be asking all the questions. So are there any questions already in the room at this stage? Okay, I can see one hand up in the back and one in the front. So we'll start here in the front, just because it's easier with the roving mic. And I think it's Svetelina in the back, yeah? Okay, you'll be second. Could you please introduce yourself and tell your affiliation and maybe who you're targeting your question to?
Sure. Good afternoon. I'm Major Allison Hauptman. I represent the United States Military Academy and the Army Cyber Institute. And my question I'm going to direct towards Anna. I'm a human AI researcher, so I really liked your presentation. Thank you for sort of considering the human factors that are generally left out of this debate. And a question I have is that because decision support systems really are going to support a wide variety of users with different expertise, personalities, cognitive capabilities, have you taken into account kind of the adaptive requirements of AI and being a decision support system, particularly things like adaptive autonomy or adaptive explainability in who and how they support?
Thank you very much. And I see we have a mic in the back, so just to give Anna a little bit of a moment to think about the answer, can we also have the second question? We'll take both of them at the same time. Svetelina?
Thank you so much. I'm not directing this question to anyone in particular, but I hope...
And can you introduce yourself? Because
yes,
many of you
Svetelina van Bentham from the University of Oxford.
Thank you.
I found this question very compelling about whether AI is raising certain unique challenges, and I wanted to ask each of the speakers whether you found something truly unique in these applications, in how they relate to the law, such that if we remove the AI tag from your analysis, we wouldn't end up with the exact same conversation that we would have without it. And then in relation to this question, what are the consequences of a potentially unique characteristic to these systems in terms of lex lata and future developments of the law? Thank you.
Thank you. So that should keep us occupied for a moment. And it's something that Eric has already highlighted specifically in his presentation, but I welcome all the other panelists to contribute their thoughts on it. So Anna, let's start with you in response to the first question.
Yes, thank you for the questions. And I think it highlights an important point of trying to address or the problems are complicated, and I'm not going to say that I'll have the solutions to address them, but I think, or what I wish to see, is that we try to focus less on just fixing the technology, but trying to work also on the human capabilities to engage with that technology. So taking the example of explainable AI, I think we also need to think about what are the risks of making something explainable too easily, because again, explainability is not creating transparency, it's just another way to put a lot of complex information into something that is more accessible to the user, but this may also come with the risk of over-trusting the system because one finds the explanations very appealing. So are we just trying to make explanations appealing in the military context? I don't think that's the purpose of, shouldn't be the purpose of explainable AI. It goes into a lot of questions. I think also how we shape interface, making it, you don't want, in the context of the use of force, the user to find it so user-friendly that it just wants to engage more. And I think these are the questions that we need to think about. And then, for instance, I had the discussions about how to solve or address issues of over-reliance. And one interesting sort of starting point would be to train military personnel to understand, to get the sensation of what it means to over-rely in a certain situation. So place them already at the training level to situations where they over-rely or under-rely, and then figure out ways that they can hint psychologically, seeing as meant to that feeling. I'm trying these things out myself. I think we can all do so because we over-rely and under-rely on AI systems on our everyday basis, and I think it's useful for us also to be more conscious about this engagement. But I think in the military context, it's even more important that we think about those ways, and I think a lot of work can be done also on that level of the human, and not just trying to bring technological fixes that may actually come with hiding another new challenges, if that makes some sense to you, or at least how I would approach the complex issues we are facing.
Thank you, Anna. Great, that's great. So now let's move on to the second question, and it's open to the whole panel. So basically about the delta that AI adds to the discussions we have had already. So who would like to start? Antonio.
Yes. Thank you, Kubo, and thank you, Svetlana, for the question. I do see something new with respect to AI technologies, and I can stick to autonomous weapon systems here. And it has to do with the fact that these are tools operating with greater independence, where a determination may be made by something that is not human. And I think from a legal standpoint, this creates two new challenges. The first has to do with accountability, because the link between a conduct and a human is a bit more tenuous. And therefore, we must, I think, rethink our accountability model in terms of responsibility, at least for the individual human beings, at the very least. And secondly, I was thinking that there are some expressions in the law that are open to interpretation, and I'm thinking about the expression arbitrary deprivation of life. And I wonder whether a deprivation of life that starts with the involvement of a machine goes in the direction of being arbitrary more than previous instances where the machine was not operating with these levels of autonomy and independence. So I think these are legal challenges that I believe are new. Yes.
Thank you, Antonio. Anyone else wanted to take this one? Anna? And then Netta?
Well, just to add a bit of another take to that question, I think perhaps what is new is not so much the legal challenges, but the way we look at existing challenges. So I think to a large extent, AI points us towards things that were either invisible or unanswered already in the past. And I see that very much as an opportunity to try to address questions in the face of the reality we're facing today, to address those challenges differently and work out different solutions, as some of which I have tried to emphasize during the presentation. So I also would not be too much afraid of challenges and frame them too much as something new, but perhaps more as a new opportunity to address also existing challenges.
Thank you, Anna. Netta?
Thanks, Kubo, and thank you, Svetlina, for the question. And it's something that the researchers that I work with and I have also grappled with, because in fact, when we started our project, we were focused on writing a guide to legal reviews of autonomous weapon systems. And in the course of the discussions, in particular with government experts, we realized that there are two buckets of challenges. One we termed persistent challenges, and the other we termed novel challenges related specifically to the technology. But the persistent challenges bucket was full, like these are, especially when it comes to legal reviews of any means and methods of warfare, legal reviews of software generally, and then specifically of AI-based software, and then specifically of machine learning-based software. There are challenges that run all the way through and are not specific to the technology, such as what is in and out of scope, a lack of access to information, and necessary expertise in the review process, lack of time, resources, etc. But then there were things in the new bucket, in the novel bucket, and in particular, that related to being able to foresee the effects of the use of that capability, the effects on the user's ability to comply with IHL, and the effects in the environment of use to the extent that that relates to assessing legality as well. There were also other new challenges related to testing, evaluation, verification, and TEVV, testing, evaluation, verification, and some other V that I've just forgotten. Because in particular of the different industry role that exists when it comes to the development and acquisition of military AI capabilities, and where that information is held, and technology as a service, not just as a product, that really challenges the ability to conduct legal reviews of these capabilities, as well as as I said, the more easily modifiable nature of military AI capabilities as compared with hardware. And the consequences, which is the second part of your question, I think there are, in terms of legal reviews, there are significant consequences, both in terms of the way in which the reviews are conducted, and it may well be that reviews of military AI capabilities are done in accordance with a different process to hardware-based reviews. But also, I think it challenges the relationship between reviewing legality prior to employment and legal advice provided to decision makers during the course of military operations and attacks in relation to specific attacks. And it blurs that notion because of the context-specific nature of how IHL is to be interpreted and applied when using capabilities that are difficult to predict and whose effects are difficult to foresee. So I think there are some significant consequences for how at least this little part of IHL is to be given effect by states when it comes to these capabilities.
Thank you, Netta. Maybe just to bring you, Eric, in as well, because I know you already flagged it in your presentation, but let me borrow from Netta this distinction between persistent and novel challenges. So one of the persistent challenges, as you have also identified it in the cyber field, is how we interpret the notion of attack, right? And so I wonder if the use of AI in offensive cyber operations might be moving this challenge from the persistent one closer to the novel bucket because of questions like material scope. What is an attack? when AI is involved? Personal scope, who decides on and who is planning an attack? Or a temporal scope, when does it actually begin and when does it end? Do you see also the same movement, or would you have a different perspective on this?
Not really. I'm not seeing much at the moment, to be honest. But for example, take an AI that contaminates another AI, and therefore a command and control center issues all kinds of weird orders. If that happens once, you could say, okay, this is definitely not an attack. But what if this happens by some bot or whatever that does it 1,000 times or several thousands of times? Can you then still say, okay, this is not an attack, even though the system still works? So nothing is done with the functional, the function of the command and control center. It still functions. It just works. It works differently. So in my view, I think that's something that the use of AI, especially in cyber operations, really adds, and is something new because of the scope. It's not just done once. It's just potentially it's unlimited.
Yeah, so definitely something also to explore in the chapter. Thank you. Do we have other questions? We have time for maybe one or two more. So gentlemen here, anyone else in the auditorium would like to give a question? Okay, you have the floor.
Hi, my name's Ian Branham. I'm an AI consultant, or wannabe AI consultant. It occurs to me that an autonomous weapon system is, at the end of the day, a weapon system. And even though it's operating autonomously, it was launched by a human. And so there may be a delay in effect, but a human knowingly launched it. Most weapon systems can be used in compliance with IHL or in violation of IHL. Some have been deemed that they can't be used in compliance. So like chemical weapons are simply banned. I can't see how. Can anybody think of, or does anybody have an example of an autonomous weapon system that cannot be used in compliance with IHL?
Who would want to take this one? Neta?
Anna. Okay. Thank you for your question. And I think that what the sentiment that you're reflecting is one that's dominated the discussions in the group of governmental experts on lethal autonomous weapons over the last 10 years, where the participants have not really identified a subcategory or a category of autonomous weapon systems that would be what's called per se prohibited by the nature of its characteristics. Having said that, I think that there are states, firstly, that consider that autonomous weapon systems are prohibited by existing international law. That at least that's been the view that they've expressed in the GGE, and without necessarily explaining how they've reached that legal conclusion. There are also some participants in the GGE who have expressed concerns about specific types of autonomous weapon systems, particularly those designed, firstly, to target people, and secondly, those that could be designed to target military objectives that are objects, not people, but that are military objectives for reasons other than their very nature. That is, military objectives by location or use, for example. And that's because under international humanitarian law, the criteria for determining whether a person is targetable or whether a military objective is targetable by nature, by location or use, those criteria are much more complex, much more difficult to translate into proxy indicators that are readable by a weapon system or by an AI system, and are more dynamic in the operating environment, more likely to change over time, in particular between the decision to launch the system and when the system may eventually apply force. And it's that risk of circumstances changing or of proxy indicators not having close enough fidelity to the reality of the battlefield that could create a situation where the system is said to be not capable of being able to direct attacks against a specific military objective, which is what IHL requires. And so there's two examples of autonomous weapon systems that states and the International Committee of the Red Cross have expressed specific concern about. And the final category that I would mention, particularly in the context of the topic of this panel, is autonomous weapon systems that rely on AI that is based on machine learning, and in particular machine learning that can adapt its functioning after the decision to launch has taken place. To my very basic understanding, such a system doesn't exist. It would be incredibly difficult to make such a system. The computing power, it's just in the field, it's just impossible to imagine right now. But that kind of system whose functioning changes after activation would be an example of a system that is simply not predictable enough, whose effects are not predictable enough to allow the user, the individual who is subject to international obligations, to international law obligations, to be able to reliably say, well, I directed this attack against a specific military objective. I hope that answers your question.
Thank you, Neta. And so, as you can see, we have exhausted our time, but definitely not the substance of the inquiry. And our work as the collective of authors working on this book will definitely continue, as I'm sure will conversations at CyCon. You know, there is another sacred rule at CyCon, and that's protecting your coffee break. So we're going to draw this to a close. I would just like to ask you to join me in thanking our wonderful panel today.